Respected Dr. Rajaram Jaipuria, Chairman and Managing Director, Guinea Filaments Limited. Sri P.K. Lahari, the Chairman of the General Council and Executive Board of the ISM, former Revenue Secretary, Government of India, and Executive Director, Asian Development Bank. Dr. M. Ashraf Rajvi, the Director, Jaipuria Institute of Management Studies. Sri R. M. Malla, the Managing Director and CEO of PTC India Financial Services Limited, former Chairman, Managing Director of IDBI Bank Limited. Mr. Shishir Jaipuria, the Vice Chairman of Institute of Management of Studies. Respected faculty members of this institute, participants, my affectionate students, friends from print media, ladies and gentlemen. I am the last speaker of this morning session. After listening to the experienced in life, experienced in administration, in various spheres, being a judge, aspects which my predecessor speakers who have spoken very well, in detail, the realities which had gone on in the country. Some of them I will respond at the end, but I must speak on the topic which is chosen for today. Before I do that, I must congratulate all the concerned, particularly the chairman and the director of this Jaipuria Institute of Management of Studies, in organizing this meaningful conference to address very, very relevant and pertinent issues which are confronting us for good governance in the country. The topic which is chosen is ethics of conference, ethics and values in Indian society. It's very, very important. Our country has got 5,000-year-old history. No other country has got this history. Our country is known for practicing and maintaining the ethical values. Is slowly degrading. That is the reason why the crisis after crisis in every field which we are seeing. Dr. Rajvi very rightly pointed out. In a democratic, socialist, democratic Republic India, where governance under the written constitution, all multi-religion country, multicultural country and pluralist society, a religion is a fundamental right of every religion which is existing and living in this country. There is a conflict between the one religion and another religion, and the religious, the writings which have been taken place throughout the country, which is a great disadvantage for the development and the progress. Yes, I agree with him. So this is a crisis where degradation of the ethical values by all the concerned and violating the constitutional principles and human values, the resultant factor is the communal writings which are taking place and conflict between one religion and another religion, despite the fact all the religions, the aim and the object is to emancipate the humanity and live in harmony and the peace and achieve the progress. And another important aspect which he has referred is between the brother and the sister, between the father and the daughter, between the husband and the wife, between the one community and another community, between one race and another race, between one sex and another sex. There are conflicts going on in the present day societal existence. This is another problem which is confronting us because we have deviated from not practicing ethical values in life. He has very vividly presented in his speech. These are all going on. This is not good for the society. And these are the aspects which must have weighed in the minds of the director and all the concerned, the professors and the management personnel, to have a conference, an ethics of conference, inviting great speakers like Mr. P.K. Lahari, and experienced the banker, Ms. R.M. Malla, and two more speakers in the afternoon, the media, electronic media, Manoj Raghuvamshi in the afternoon, which will be followed by a panel discussion. That's why I congratulated this Jaipur Institute of Management, particularly under the leadership of the director, Dr. M. Ashraf Rajvi, inviting the industrialists, the academicians, the journalists, the bureaucrats, the administrators, judges, the students community, to invite and ignite your minds, to ponder over the subject. The deviation from the ethical values is the resultant factor in creating crisis after crisis, which will endanger the rule of law, and it will affect largely the civil society, and there will be difficult for good governance by all the concerned. Another experienced in life, Dr. Rajaram Jaipuria, who is responsible for this kind of the forum, because this Jaipur Institute of Management Studies, I was so much moved from his speech. very emotional, became very emotional. When he was presenting his personal note, how he underwent a crisis, how he faced it, how he thought of the society, the societal need, and the human values, and the humanity, I was very much moved from his talk. His sacrifice and dedication is today this meaningful institution which will produce large number of students who are going to take over the reins of the power of this country. You are preparing the responsible citizenry to undertake the responsibilities of these countrymen. Knowledge is power. That is the industry which you have created here. That will be more beneficial for the mankind. So I was very much moved with his personal note. So therefore, it gives a great confidence in all of us. Whenever we are in crisis, rightly, Lahari also has referred to very important and salient aspects. He spoke about the corruption, how he personally confronted with the problem with the political executives, how he had prevailed, how his courage and conviction made to overrule, or no, he has no overruling capacity. How he could able to sustain himself and see that the public interest must prevail with reference to the policy matters where waiving off the custom duty to a charitable, so-called charitable institution. All these things which will create and gives us knowledge, the experience to every one of us to move forward and to reorganize ourselves and rebuild ourselves and defend, to bring back the ethical values which is lost among ourselves because of various reasons, particularly insofar as I am concerned, the situation is because of the existing societal setup. That is the reason where the degeneration of not following the ethical values, the code of conduct by all the concerned in the respective fields is the resultant figure today which we have been led in the great crisis after crisis, according to my understanding, that we are required to overcome. This kind of conferences, different minds, different thinking, different personalities, and all concerned joined together, listening to the persons who are experienced in life, telling us the realities, ongoing realities of the society, and recalling our memories that we are required to maintain ethical standards and the values for the purpose of the good of the society, to protect the society, to live happily, peacefully, coexistence. These kind of conferences will help. Therefore, this will move forward. This will not stop from this conference. After listening to the speakers, the participants must take the message which is being delivered by speakers, and your participation, your interaction will take us forward to regain what we have lost. If we have lost, And we must also trace out what are the reasons, basic reasons for this. And we must address those basic issues. Then everything will be all right. The object is very certain that ethical values and ethics in Indian society is very, very important. I 100% agree with them, and we all must work together to regain it. I have been asked to speak on this aspect with reference to the judicial services. The judicial service is a very, very pivotal role playing in a democratic Republic India. The written constitution, which is given by the great architect of this country, Dr. Ambedkar, well thought over, Bhagavad Gita. Every religion has got their own Bhagavad Gita. Hindus have got Bhagavad Gita. Islam has got the what is called the Quran, and the Bible, the Christians. Different religions, they have got their own religious text, injunctions to be followed for the good of the people. So under the constitution, the constitution is Bhagavad Gita of all the religions. All religious practices are protected, kept intact, respected. A state must consider, must respect each religion equally. That is why Article 25, 26, 27 are kept in the Part 3 of the fundamental rights of the Constitution, and Part 4 is the directive principles. Both parts constitute the human rights of the country. The good governance is also shouldered on the responsibility of the Indian judiciary. The third limb of a strong independent judiciary is the third limb of the Constitution for good governance. And the judiciary is the guardian of the Constitution. Therefore, I said, the judicial service is very, very important and onerous, very pivotal role to be played for maintaining the rule of law. This wing or limb of the Constitution is not only the protector or a guardian of the Constitution, where the human rights are given to the people of this country. It oversees the functioning and good governance of other important two wings, namely the legislature, who legislate the law, to discharge its constitutional functions, keeping in view the constitutional philosophy and the concepts of equality, equal opportunity, irrespective of the sex, religion, creed, caste, color. And the executive, to which were important role played by our Dr. Sri P.K. Lahari, a very, very important law which is made, or the executive actions which will be taken, policy matters, policy decisions are required to be implemented by the executive. These two limbs of the Constitution required to be governed and overseen by the judiciary. The judiciary in India, under our constitutional setup, is very, very independent, and it is required to play a very important role to protect the liberty, the equality, the fraternity of the people of this country. The fourth limb of the constitution of the state is the journalists, the media. They are discharging a very, very important role in making all the concern to discharge their function very effectively, correctly, to bring home the point. All the concerned are required to function within the parameters of their role, which is assigned under the Constitution for good governance. So from this viewpoint, we are required. I have to address you. What is this judicial service and what are its parameters? What is its role? Is the judicial service required to strictly adhere to and follow the ethical values? Yes. The judicial service is distinct and different from public service. The bureaucrats who will be there in the executive, which is a second limb of the Constitution, is from the public service. The judicial service is different and distinct from public service because we have got a different role and there are certain immunities, privileges given to the judges and the court officers. The judiciary consists of the lawyers. From among the lawyers, the district judiciary members, the constitutional judges like the High Court and the Supreme Court are being appointed. So therefore the two important partners, stakeholders of the judicial service is the lawyers and the judges. Insofar as the lawyers are concerned, they are all governed by the Advocates Act of 1961. It is the law which is enacted by the Parliament. There are rules framed by the central government regulating the function of the lawyers in the courts, constitutional tribunals and other incidental fora. There is a written law, written rules which governs the lawyers to effectively function, assist the judges and the courts to render justice to the respective parties. So therefore, lawyers have got a very important role. P.K. Lahiri has rightly referred to the great statesman of this country. The first Prime Minister Jawaharlal Nehru, Sardar Vallabhbhai Patel, the iron steel man, Rajendra Prasad, the first President of India, Mahatma Gandhi, the father of the nation, who is a barrister, who is a crusader to liberate the country from the colonial rule. These are all our role models. To follow them, to follow their footsteps, to see that the country is taken towards the forward, to achieve the constitutional goals and aims. So therefore, the great giants, they are the statesmen, they are the thinkers, they are the social architects, they are the great politicians, great administrators. who have been in the helm of affairs at the initial stage when we got the independence. And it is they who are responsible in giving this Bhagavad Gita of Constitution. Under this Constitution, the independent judiciary, the lawyers are required. They have got the fundamental right guaranteed under Article 19(1)(g). The right to practice is a fundamental right guaranteed under Article 19(1)(g). Nonetheless, they are the court officers, though it is a private practice like a doctor, but they are regulated by the law. Lawyers are regulated by law called the Advocates Act 1961. Lawyers are required to follow certain ethical values. They are governed by the provisions of the Act and the rules. They may be independent practitioners, still their practice and profession is regulated by the Bar Council of India and the respective state bar councils, which have got a statutory flavor under the Advocates Act. If they commit a conduct of a professional misconduct between himself and the litigant, he will be subjected to disciplinary action. That is very much required. Otherwise, the important wing or the limb of the Constitution to render justice, where the last ray of hope of the people, of millions and millions of the people of this country and the masses of this country, will be eroded, lost, and rule of law will be not there. If rule of law is not there in a country, then you know what will happen. I need not tell you. Insofar as the judges are concerned, there is no written code or conduct rules, but it is self-regulated conduct and the rules for functioning and conducting themselves to see that they have got an authority. The authority is the constitutional power. Insofar as the constitutional judges are concerned, that is the High Court and the Supreme Court. The district judiciary is concerned, they have got the constitutional powers, statutory powers for adjudication of the disputes between the individual litigant and another individual litigant, between the husband and wife, between the father and the children, between the brother and the sister, between one state and another state, between one state and another single litigant, individual litigant. The state will have the wide, the strong power. The individual litigant and the state question comes before the court, and the lawyer, and lawyer defending one individual litigant against the state. The state is a enormous power and the stamina. The judge is required to balance and decide the rights between an individual litigant and the state. Who is correct? Who is not correct? Justice is in whose favor is required to be decided by a judge. So judge has got enormous power, authority, and the responsibility. Association, they will have an association. Right to form an association is a fundamental right guaranteed in Article 19(1)(a). Form an association, they may pass a resolution. We don't like the proceedings which are being conducted, no adjournment is given, or we will go on with the strike to seeking for our democratic rights. We do not have good library, we do not have good computers, we do not have the accommodation provided by the responsible government, therefore we will boycott the courts. Or there is a conflict between the police officer and the lawyer, there is action must be taken against him. Till then we will not come and participate in the court proceedings. It is not open for the lawyers to abstain from the courts. This aspect of the matter, long back, is decided by the full bench of Calcutta High Court. AR 1923, Calcutta, page 212. The full bench of the High Court held that pleaders deliberately abstaining from attending the court and taking part in a concerted movement to boycott the court was a course of conduct held not justified. You can't take a shelter, you can't take a defense if the case is dismissed for default. And their conduct is objectionable conduct, it is a professional misconduct. So therefore, they are governed by the law. The pleaders had duties and obligations to their clients in respect of matters entrusted to them, which were pending in the courts. They had duty and obligation to cooperate with the court in the orderly administration of justice. Boycotting the courts was held to be high-handed and unjustified. You can't say, I have got right of freedom of expression. Yes, you have got right of freedom of expression. You have got right of freedom of association. When once you accept the brief and file, you are a court officer, you must know. You are a lawyer, independent lawyer. At the same time, you are a court officer. You cannot abstain from the court and you cannot boycott the courts to assist the court, enable them to decide the matter and adjudicate the rights of the parties. You can't take the courts into ransom because you are a court officer. So therefore, you can't boycott. Boycotting the court was held to be high-handed and unjustified. In reference AR 1924 Rangoon 320, a division bench of High Court held that a pleader abstaining from appearing in the court without obtaining his client's consent and leaving him undefended amounted to unprofessional conduct. If any counsel does not want to appear in a particular court, that too for justifiable reasons, professional decorum and etiquette require him to give up his engagement in that court so that the party can engage another counsel. But retaining the brief of his client and at the same time abstaining from appearing in that court, that too not on any particular day, on account of some personal inconvenience of a counsel, but as a permanent feature, is unprofessional, as also unbecoming of the status of an advocate. No court is obliged to adjourn a cause because of the straight call given by any association of advocates or a decision to boycott the courts, either in general or in particular court. It is a solemn duty of every court to proceed with the judicial business during court hours. No court should yield to pressure tactics or boycott calls or any kind of probity. It is an established practice with the lawyers to do nothing that shall detract the dignity of the court, of which he himself, a sworn officer and assistant. He should at all times pay deferential respect to the judge and scrupulously observe the decorum of the courtroom. This is from the Warwell's Legal Ethics. Though no legal code has been framed for judges, as I already told you, the bill is pending before the Parliament. However, the rule of ethics apply equally to the judges too. The judicial process demands that a judge move within the framework of relevant legal rules and the covenanted modes of thought for ascertaining them. He must think dispassionately and submerge private feeling of every aspect of a case. There is a good deal of the shallow talk that judicial robe does not change the man with it. It does. The fact is that, on the whole, judges do lay aside private views. A cause may come before us. We may have our different views in a particular aspect, different perception, but our personal views cannot be put into that case and this while deciding the case. The whole judges do lay aside private views in discharging their judicial functions. This is achieved through training, the professional habits, self-discipline, and that fortunate alchemy by which men are loyal to the obligation with which they are entrusted. Every judicial member, either a district judiciary or the constitutional courts, are trained in the respective state judicial academies and the national judicial academies. The training programs on the ethics and ethical values, regularly it will be given in the state, in the national level, in the regional level. This is to train them to adjust to the professional conduct of a judge, how to conduct himself, how to conduct outside the court, inside the court, while deciding the matter, what should be said in the court, how you have to react, how you have to decide, how you are required to adjudicate, how you have to, in which functions you have to participate, how to address, where to address, on what matter you have to address. All these things training will be given in the judicial academies. That is one side. The another side is we have got our inbuilt vigilance section will operate. It is very, very difficult for a function to function as a judge. The moment you decide the cause, earlier time there was no difficulty. Now, for former Secretary Mr. Lahiri has pointed out a series of cases regarding corruption. To deal with this kind of cases, it is not an easy job. But we have to decide. Our oath of office is like that, without fear or favor. Under the Constitution, we take the oath. Not only the constitutional functionaries, the other judicial members also, district judiciary, they will also take oath. So therefore, here, the moment you decide the case, there will be either written complaint, anonymous complaint. Those proceedings we will be processing, monitoring by the respective, the portfolio judge, the Chief Justice, and the committee of the judges. So therefore, the code and conduct and ethical value is maintained or not, followed or not, it is being monitored by inbuilt mechanism in the every High Court. Here and there may be some aberrations. We are part of the system All judges are not coming from the heaven. I am not saying in a system, here and there are some aberrations. I don't want to react to those. I am only telling the ethical values and ethics is being very strictly adhered to and followed, required to be followed in the larger interest of the protection of the institution. The judiciary is an institution. The President's office is a constitutional institution. The Prime Minister's office is a constitutional institution. The Chief Minister's office is a constitutional institution. These institutions are required to be protected because these institutions are meant for the masses of this country. You suppose, if the lawyer does not appear in a magistrate court, an innocent person is arrested. He will be produced before that magistrate. Lawyer does not appear. He will not be in a position to tell to the judge, look here, it is a fabricated case, foisted case against me. My liberty guaranteed under Article 19 is affected. Enlarge me and bail. Don't send me to the jail, judicial custody. His liberty is curtailed. Liberty is a very, very, very precious fundamental right. That one person will feel it if your movements are curtailed, you are kept in a four-corner wall room. If you can't move, you can't speak to your family members, you can't earn your livelihood for your family members, that liberty is curtailed. The liberty is a very, very precious right, which is the basic feature of the Constitution, is interpreted by 13th judgment way back in 1974 Supreme Court in Keshavananda Bharati's case. So, the courts are protecting the liberties of the people, protecting the life and liberty, equality, equal opportunity, the material resource for the common good. So therefore, the judges are trained, professional habits will be inculcated, self-discipline will be taught to them, and in that way they will function. The need for a formulated code of ethics, judicial ethics, has been discussed by the Supreme Court in previous occasions. Often a coded form of guidelines saves the judges of malicious allegations brought against them. The Supreme Court has opined that we have been passing through a period of exceptional strain and stress and excitement in this country, in which unusual remarks made have not been confined to what happens in the newspapers. Indeed, extraordinary and surprisingly erroneous statements which could not be there if rules of judicial ethics were formulated and strictly adhered to, have found place even in solemn pronouncements of this Supreme Court. On rare occasions, however, I do not want to expatiate on that theme here. All I can say is that if this is a correct observation, it would also disclose a need for rules of judicial ethics or propriety for judges, even this August, even to all the courts. I was also observed in the same, the national interest requires that all criticisms of the judiciary must be strictly rational and sober, proceed from the highest motives without being colored by any partisan spirit or tactics. This should be a part of national ethics. The ethics of judging involves various aspects, the most important being judicial discretion. Discretion enters into judicial activity in a number of ways. One can be concerned more specifically with how judges make decisions where they are given latitude to do so. 2. how judges conduct themselves and utilize their authority in relation to those they judge. Examples of first sort come most readily to mind when we think about judges exercising discretion, settling bail for a defendant. I will come and tell with regard to the central bail policy immediately after this aspect which is raised by him. The element of discretion. Setting bail for a defendant, deviating from sentencing guidelines, and rendering decisions about whether certain evidence is admissible are all examples of exercising discretion in this. We conduct the Lok Adalat, we play a role as a mediator, conciliator, and settle the matter by telling our experience, getting their problem, interacting with them, the matter are settled. Large number of, in fact, last November 24th, Justice Singhvi was the executive chairperson of National Legal Service Authority. Call was given to the whole country, participate in the Brahat Lok Adalat and settle the cases. It is more than 74 lakhs of cases were settled in that month, is the record break. So this is the skill of a judge, skill of a lawyer, skill of a mediator. And sometimes we persuade the parties, we persuade the husband and wife in the larger interest of the children to see that the cases are settled amicably in the larger interest of the children and to see that the matrimonial home is not broken. So this is also a role that will be played both by the lawyer as well as the judge. So exercising discretion involves making myriad decisions every day about how to balance justice and mercy. They say justice must be tempered with the mercy in not all aspects. A gruesome murder of a family member killing four, if it is proved, there may be evidence on record, and death sentence which is abolished in other countries, death sentence not abolished in our country, whether in such circumstances, in the absence of mitigating and extenuating circumstances into consideration, in that case, the conduct and the antecedents of that the accused person requires the mercy to be shown to such person is the question. Such cases, in my view, if it is proved, the guilt is proved, the gruesome murder has taken place, mercy, justice cannot be tempered with mercy there. That is because it will be a menace to the society. It will be a utter violation, blatant violation of the rule of law. What rule of law says? Law and order to be maintained. Mr. Rajvi was referring, there is no safety for our young girls. This is what we are seeing for the last 1 year, more predominantly in Delhi and other places. So to keep the society intact, to instill the confidence in the minds of our young children who are going to the college, attending and going to the home in the night. In such cases, if an act of rape, an act of assault, an act of the bad behavior, that's why the amendment on the basis of Verma's report, the former Chief Justice, late Verma. So, justice must be tempered with mercy by a judge to exercise discretionary power only in the cases which deserve, not persons who are violators, who are murderers, who are dacoits, who are antisocial elements, who are menace to the societal setup. Mercy is not required. Mercy is required where a soul-earning member commits a mistake, a misconduct. That must be one act. Antecedents are good. Then to give him opportunity to see that livelihood is given to not only to him and to the family. Mercy may be required to impose lesser punishment. A juvenile commits a mistake, not grave offences, which will be affecting the social fabric. No. That is why Probationary Offenders Act of 1955 is very much there. Justice is tempered with mercy there. So that is protected. That I am telling, the judge mind will be perplexed. Judge mind. It is not, it is a decision making process. It is not a simple thing. It is not a simple thing. Sir, whether a death sentence or a life imprisonment or what punishment to be given is a very, very onerous responsibility. He has pointed out, you have no right of giving a birth. That means, have you got right of taking away? That is the enormous, taking away the life of a person is the power conferred upon the judge, upon the court. That is the authority. That means, what an amount of enormous power is conferred upon you. That's why in India or anywhere, it is called God in existence, in appearance we may see or we may not see. In idol form we may see Hindus or other religious persons. But insofar as the litigants are concerned, the judge, we will be telling in our academies, you are a demigod for them. Therefore, you must be very, very careful. You must be extra cautious. You must be reasonable. You must be fair while deciding a cause or a case of that litigant. See, if you look at one individual litigant and against the state, state is a mighty state. They engage the senior counsel. A poor man is not in a position to engage. A person from Kanyakumari traveled to the Supreme Court. He may not be in a position to engage a lawyer. We may give him the legal aid lawyer, panel lawyer. He may not, on par with a senior counsel, engage Attorney General or Solicitor General on behalf of the state or the government of India. But still, the scale in the hands of a judge, whether justice is in favor of individual or not, is the decision-making process. That is vast, that should be balanced, that should be weighed. You must apply your mind. You must impartially decide without fear against the mighty state. You have to decide. That is the conduct, the code, ethical value, which are required to be followed by a judge. Before I go to the topic, our another speaker, Mr. Mala, was referring in a lighter way. He said, a lawyer, because of his eloquency, because of his the caliber, a accused person who is a murderer, he will get acquittal. That may happen here and there because maybe decision-making process may be erroneous. That can be corrected in the higher courts, that is appeal is provided, first appeal is provided, second appeal is provided. We will see such kind of the erroneous decisions will be corrected by the higher court. But a intelligent lawyer and a clever lawyer, it may not be the criteria to argue. Eloquency, his language, his presentation of case itself is not sufficient for acquittal of a murderer. Murderer, the job of a judge is collection of evidence by the investigation officer. If the investigation is not properly done, material is not produced, either eloquency or presentation of the case, the skill of a lawyer, skill in eliciting evidence in the cross-examination from the prosecution witnesses may not be the relevant criteria. But of course, an intelligent lawyer can prove that it is a foisted case. That is because of his skill and acumen, the jurisprudence knowledge, either medical jurisprudence or the criminal jurisprudence. He can elicit evidence and show he is a five-state witness, five-state case. In such cases, the efficiency and skill of a lawyer may be relevant, but not in all the cases. If there is no evidence, we are required to decide the case on the basis of the material evidence on record. We can't blindly, because he is termed, he is a murderer, he is a dacoit, he is a robber, he is a corrupt official, he is a corrupt politician, therefore convict him. We can't go further. On the basis of evidence we are required to decide, because we are expected to evaluate, analyze, apply our mind and exercise our discretion. That discretion must be judicious discretion, and our decision must be fair decision. It must be reasonableness, and it must pass the test of reasonableness. If it does not pass the test of reasonableness, it will be arbitrary. People will not accept it. Very, very difficult. Here and there, as I already told you, somewhere something must have happened, but that will not happen in all the cases. So that is because the training, the professional equipment, the efficiency, we try to make the judges, and we, including ourselves, try to equip ourselves when we go and hear the matter and decide. It is not very casually, we will not do that. That is because we are expected. The expectation from us by the people is so much. That is very, very important. So therefore, the people may talk outside without knowing the procedure, and without knowing, we can't help it. If they talk, we don't have opportunity to go and clarify it outside. Very difficult. Therefore, you the public, you the journalists, you the senior citizens, you the students must come to the rescue of the institution. It is a constitutional institution meant for the masses of this country. If the judge is not there, judiciary does not function, there will be chaos, there will be crisis, there will be a violation of rule of law, there is no fundamental right, or the human rights will be violated. We are the guardians for that. Kindly remember this. Therefore, large object is to see that the judiciary, which is a third important limb of the Constitution, required to be protected. That is the larger interest. Secondly, the judiciary has the power to take suo motu cognizance of the matters affecting people. Look at here, the role which is played by the media. Very, very important. 2 weeks back, a tribal girl in West Bengal, raped. It was brought to the notice. It was published, widely published. The Chief Justice took up the matter, suo motu. Issued the notice to the government of the West Bengal state, answering why, what action you have taken. This is the obligation on the part of the judiciary. And because of the role played by the journalist, it aided the court, suo motu proceedings were taken, and it is matters pending. Such matters are plenty. Not only that, the Gowda case, way back 1986, Gowda is a great journalist from Bombay. The slum dwellers in Bombay, the Constitutional Bench, 1986, Supreme Court, page 180. The minority view of the United States of America has become the majority view after interpretation of Article 14, 19, 19(1)A, 19(1)G, 21, Supreme Court, paragraph 32, in the Olga Tallis, who is a journalist, that makes today the vendors bill which is pending before the parliament. That is the law which is large number of people on the vegetable vendors. The people who are making their livelihood early morning with hand rickshaw pullers, all these people. So for them, he is a citizen. He is governed by the fundamental rights, part 14, equality, equal opportunity, fundamental right of business, and life includes livelihood. Livelihood without source of income. What is the source of income? Source of income, vending on the street. He is the source of income because he doesn't have any other income. That is recognized by the Supreme Court. That is the instance of a journalist, the Olga tells. Not only that, Basu's case, way back in 97, a arrestee, if police people arresting the person, they were damn afraid. Third-degree methods. It is the journalist Basu which made the constitutional bench of the apex court to write a judgment. Arrestee has got right under the constitution, right under the criminal procedure code. So we are required to balance. We are required to look after the rights, fundamental rights, vis-a-vis his duty towards the society. While doing it, you have to do it in a fair, reasonable manner, not arbitrarily. Because he is an accused person, you can't subject him to the third-degree methods. That is not permissible. So look at the responsibility entrusted to the court, which is brought to our notice. We have laid down the principle. He is one of the important leading the constitutional bench judgment. Both Volga-Tellis and this Basu's case, 97, Supreme Court case 606, are being appreciated in the international level. The Volga-Tellis case in the United States of America, Australia, Canada, and other courts is being cited as a precedent. That is the remarkable achievement which the Indian judiciary made, protecting the human rights of the people. That is because we have got that stamina and the courage and the conviction of ethical values which is being followed. If you do not have that ethical value, you will not have the moral courage to stand before the people and talk. And every judgment is a public document, it is a public property, it is being debated, it is being criticized, but we will not react. We expect the constructive criticism, but not destructive criticism. We expect it. Destructive criticism demolishes the institution. If you demolish the institution for which you have no right, it will affect the rights of the masses of the country. This is what is said by the United States of America Supreme Court in that judge case, Bombay High Court Chief Justice Bhattacharya, when he was in the Bar Association of Bombay High Court, passed the resolution, and that was the subject matter before Supreme Court. Justice Nariman, the veteran lawyer, appeared as amicus curiae and assisted the Supreme Court and said, court is meant for the masses of the people of the country. You can't demolish the existence of a constitutional court. It is a constitutional institution. If you demolish it, you are demolishing the rights of the masses of this country. That's what is referred to by the United States of America. This is the contribution. This is the development which a judge who is part of the institution required to follow the ethical values, etiquette to the client, to the nation, to the lawyer, to the public litigant, whoever comes before the court. If a person do not subject to these kind of the ethical values, it is very, very difficult to discharge the constitutional function. And further, look at the power. Article 141. The decision that will be made by the apex court will be binding on everybody. It is not the parliament law. Interpretation of the law, and in the absence of law, law laid down in that 1998 Supreme Court, where from the Rajasthan case, 98, where the woman sexual abuse in the workplace is not permissible. that binds. The judgment law, 141, enormous power. Law is binding. And 142 Constitution empowers the Supreme Court to pass any decree, any order, which is necessary for doing complete justice. Complete justice persons who come before us, who do not have the right of residence, who do not have, you must have seen how in Delhi High Court, Supreme Court, when on account of lack of shelter, during winter season, people dying, we give direction to the responsible government to provide shelter homes. Because of the directions of the Constitutional Court, shelter homes are provided. This is the functioning of the court. So therefore, in the interest of the public at large, the equitable orders can be passed by the Supreme Court under 142. A very historical judgment rendered by Justice Singhvi, another case which that I conclude my speech, where in Harjinder Singh case, he is an employee in the Road Transport Corporation. While deciding that case of a worker who is ordered to be reinstated, interfered by another constitutional court examining 226 and 227. Justice Singhvi, a historical judgment is rendered in Harjinder Singh case. He has said that, I quote, "We consider it necessary to observe that while exercising jurisdiction Article 226 and 227 of the Constitution, matters like the present one, High Courts are duty bound to keep in mind that the Industrial Disputes Act and other similar legislative instruments are social welfare legislation, and the same are required to be interpreted keeping in view the goals set out in the preamble of the Constitution and the provisions contained in Part 4 thereof in general, and Article 38, that is the social order, 39A to E, various rights given, 43 and 43 capital A in particular, which mandate that the state should secure social order. We are part of the state. Judiciary is a part of the state, is held in Keshavananda Bharati's case. For the promotion of the welfare of the people, ensure equality between men and women, and equal distribution of material resource of the community to subserve the common good, and to ensure that the workers get their dues. About 41 years back, Gajendra Gatkar Jay, in the case of State of Mysore versus workers of gold mines, reported 1958, way back in 1958, 1903, he has laid down the principle, I quote, concept of social and economic justice. That is the preamble of the Constitution. Preamble is the basic feature of the Constitution. It is a living concept of revolutionary import. It gives sustenance to the rule of law and meaning and significance to the ideal of welfare state. This is to say that judiciary, though it is considered to have a wide range of discretion in decision making, in real sense of term, judges are bound by the principles enshrined in our Constitution, both in Part 3 in terms of our fundamental rights and Part 4 of directive principles. Since the judiciary is the guardian of the Constitution, it also carries responsibility of protecting the values preserved in our Constitution, which includes welfare for the poorest of the poor, inclusive growth and justice for the last person. Our Constitution recognizes the good traditions, the heritage and values and human values to protect the humanity, giving rights to the people of the country, protecting the equality class, irrespective of a person who stays in the slum, persons who stays in the mansion in Delhi. This is the constitutional concept. We are governed by the constitutional concept. We are required to discharge our functions and keeping in view the ethics and values to render socio-economic justice to the people of the country. Thank you very much for giving me this opportunity, presenting my views. I I have presented certain views for because of my office. It is not possible for me to react and respond. I like the presentation of all the speakers. I hope and trust the participants will put number of questions to the panelists. You can discuss, debate. From this message which you have been given, carry forward, take to the people of the country, make them participate, alert and see that participate in democratic process to keep all the institutions, to keep all the concern intact and function responsibly and discharge their responsibilities onerously in the larger interest of the country. Thank you very much.